Okay, hello and good afternoon and welcome to 39 Essex Chambers Planning, Environment and Property Seminar for Bristol and Cardiff. What we normally do each year is to go to various sort of regions, various locations, usually pick a quite nice hotel and do a seminar as an update on what's going on in planning, environment and property topics. This year, as we all know, has been somewhat different. So we're sorry we've not been to Bristol and Cardiff as we would normally do. So what we've done is set up a series of seminars which will be focusing on issues of interest to those particular regions, but almost everything we're going to talk about will have a relevance to elsewhere. The three of us presenting today. So I'm Richard Harwood and my colleagues David Sawtell and Gethin Thomas, who are going to be talking to us as well. What you find is that we've got a Q&A box at the bottom of the screen. So any questions, any comments, whether it relates to the presentations we're making or just anything else of interest in on planning environmentally you'd like us to talk about, please do sort of put in those questions and we will pick those up at the end of the seminar. Slides will be posted online within the next day or so, so don't get too worried about taking too many notes of that, as well as a recording of this. So that's probably more than enough as an introduction, and what I'd like to do is to pass over to Gethin to take us through the first of the interesting developments which we're dealing with.
Thank you very much, Richard. Good afternoon. So I'm going to be speaking on two topics. The first, the recent changes to the use classes order, and secondly, I'm going to look at some Wales-specific developments. So looking first at the Town and Country Planning Use Classes Amendment, England Regulations 2020, which were laid the day before Parliament's summer recess on the 21st of July 2020 and came into force at 10 AM on the 31st of August 2020, the day before Parliament reconvened. And the changes made by the regulations create, as I'm sure most of you now be familiar with, new use classes in relation to England. And it came into force when it came into force, the government explained that, and I quote from the impact assessment, that these reforms to the use classes are primarily designed to help support vibrant mixed-use town centres. They apply to all uses of land and buildings in town centres and elsewhere across England. It's important to bear in mind these do not apply to Wales, and as I said, I'll come on shortly to some Wales-specific developments. For now, these are exclusively on this side of the border. By way of very brief context, as you'll all know, planning permission is required for development as defined in section 55 of the Town and Country Planning Act 1990. The making of a material change in the use of any building or other land is normally defined as development and therefore requires planning permission. What section 55(2)(f) of the 1990 Act does is allows the Secretary of State to make an order which groups different uses of buildings and other land into use classes. That has the effect of a change occurring within a single use class no longer being considered as development at all and therefore doesn't require planning permission. That's a very basic proposition that you'll all be aware of, but I think it's important to bear it in mind because it has key implications for the extent of control that a local planning authority may be able to exercise over the use of land following the implementation of the 2020 regulations. It's no exaggeration, I think, to say that the 2020 regulations make radical changes, not just to the Use Classes Order 1987, but to the planning system itself. This is a self-described complete overhaul of the Use Classes Order. I think equally, it would not be too great a leap to see the 2020 regulations as perhaps the tip of the iceberg in terms of the reforms to the planning system. The 2020 regulations are just the beginning of the process, perhaps a radical revolution, which has been trailed in the government's white paper, which was published in August this year. And I think the 2020 regulations reflect, for better or for worse, the kind of deregulation that could perhaps be expected in the near future. I think in particular, the 2020 regulations epitomise the two overarching policy aims which were set out in that summer white paper for the future of the planning system as a whole, being first, the simplification of the planning framework, and the second, moving towards what's termed a rules-based, which impliedly I think really means automatic, rather than discretion-based planning decision-making process. I think therefore, when considering the 2020 regulations impact, it should be borne in mind that the context in which the use classes order will sit in the future in terms of the wider planning system will itself be quite different. Please go to the next slide, David. Now, as you'll be aware, the use classes under the 1987 regulations were broadly grouped into four overarching classes. A classes covered retail, food, drink, consumption. B classes covered work, like offices, manufacturing. C classes covered places of residence, and D classes, institutions and leisure uses. And the regulations amend and simplify the system of use classes in England by creating new use classes which are contained in the new Schedule 2 to the use classes order, namely Class E, commercial, business and service, which is an amorphous class which has swallowed up all of the diverse use classes which are set out there on the slide. For example, a cafe or restaurant could be converted now to a gym or vice versa, and that change of use would no longer constitute development. As you can see, this is an extremely wide-ranging use class, and this single change has perhaps the biggest impact on the Use Classes Order 1987 by itself, and it facilitates significant changes, in particular to the high street, as well as out-of-town centre industrial parks. On the government's estimate, the number of buildings in scope of the new Class E commercial business and service is around 1.5 million. Class F1 is more of a rebranding of Class D1, simple rather than fundamental change. I set it out there for completeness. Class F2, like Class E, is also combining a relatively disparate array of current use classes into a single new class labelled broadly local community. And the three classes, it combines Class A1 shops, Class D2 hall or meeting places, and outdoor or indoor pools, skating rinks, sports, recreations, and so on. The placement of the Class A1 shops in F2 rather than in E is an attempt to protect smaller shops outside main shopping areas, particularly in rural communities and large residential estates. In its impact statement, the government has explained that F1 and F2 are intended to ensure that those uses which are important to local communities have some protection through the planning system, because the scope to the change of use without permission is more limited in those two F classes. And although they are more limited in scope by comparison to the huge scope of Class E, Class F2 is still itself very broad. The residential C classes, general industrial B2, and storage and distribution B8 use classes remain unchanged, although, as I'll come on to briefly, there have been some changes in respect of permitted development rights for Class C in particular. A number of uses have been erased from existence completely, and there are a number of uses identified in Article 3.6 of the Use Classes Order, which are just simply not use classes anymore at all. These include, for example, the former A4 drinking establishments and A5 hot food takeaway use classes, cinema, concert, dance and bingo halls, which fell within the former D2 class, and venues for live music performance. The consequence of this is that any change of use to or from those uses requires planning permission, which is intended to ensure greater control over those uses. The government have expressed concern that, in particular, hot food takeaways, it says, can encourage unhealthy eating, and live performance music venues can create noise late at night. The key implication from the 2020 regulations is the significant shift in control away from local authorities into a significantly less regulated environment. Plainly, the amenity impact of a cafe or a restaurant is going to be significantly different to that of an office, which is different to that of a creche, and is different to that of a shop, and so on. But a single unit on the high street or an industrial park could rotate theory between all of those uses now without being subject to planning control. There are also potentially wide-ranging secondary or indirect impacts on other processes, such as valuation. Equally, however, it must be said, the flexibility is, of course, not without its benefits. The high street retail and hospitality sector are in the throes of well-publicised challenges with no abatement in sight. Moreover, there is bound to be a marked decrease in demand for B1 office units given the now well-established trend of home working. Therefore, the opportunity to more easily switch a unit between different uses to pursue new business opportunities may well help more swiftly to reduce the number of vacant properties. So is there any scope for taking back control on the part of local authorities? Well, first, conditions. Prospectively, conditions may be attached to an individual development's planning permission to restrict a change of use within a given class. However, the imposition of any such condition must meet the test of being necessary, relevant to planning, relevant to the development, enforceable, precise, and reasonable. It's important to note that the Secretary of State has a power under Section 100 ZA of the 1990 Act, which was introduced pursuant to the Neighbourhood Planning Act 2017, to restrict the power to impose planning permissions, planning conditions in England. I think it's not beyond the pale to imagine that that power could be exercised to limit the ability to use planning conditions in that way. But for the moment, at least, for forthcoming developments, conditions properly imposed are really the main, I think, in effect, the only way going forward that local planning authorities may take back some control. It's not possible for local authorities to use Article 4 directions to claw back some control of changes within a use class, because Article 4 only applies to permissions granted under the GPDO, and the use class's order exempts certain changes of use from requiring planning permission in the first place. So Article 4 doesn't help. Carefully drafted local plans are also a prospective tool in the sense that there will be a material consideration as to whether, for example, permission for a Class E development is to be granted in the first place in a particular case. But again, won't really be able to touch movements within classes for the reason said at the very beginning of the presentation, that movement within classes now is no longer development at all. In terms of future reforms and the General Permitted Development Order, the transitional or savings provisions in the 2020 regulations apply only from the 1st of September 2020 to the 31st of July 2021. And this is referred to in the language of the regulations as the material period, which preserves the old use classes for the purposes of the General Permitted Development Order 2015 for that period. And there are a number of existing permitted development rights which grant planning permission, allowing changes of use between use classes, and the savings provisions which retain the effect of those rights based on those classes in place prior to the new regulations coming into force. Revised permitted development rights are expected, therefore, to be having effect from the 31st of July next year. No draft regulations have yet been published. Obviously, a significant but important unknown is what the government will do in respect of office to residential permitted development rights. B1 as a use class no longer exists, and it would be extremely surprising, but perhaps theoretically not entirely out of the question, for the government to, for example, permit Class E to C3 development and vice versa. But the position of planning regulation in respect of converting commercial business property to residential is significant for obvious reasons, and will likely to only have more importance given the impact of COVID-19 on commercial properties and on the hospitality industry. And landlords may well very much welcome looser regulation allowing residential conversions, but at this stage, one can only speculate on what the position may be. And the only clue at the moment is the text of the white paper, an extract of which is on the is on the slide there, which makes clear that legislation is proposed to widen and change the nature of permitted development so that it enables popular and reputable forms of development to be proved easily and quickly, supporting what is termed gentle intensification, which is debatably something perhaps of an oxymoron. Discrete changes to permitted development rights have recently been made to the general permitted development order pursuant to 3 sets of regulations, which I'll very briefly summarise in turn. The overarching thrust of these regulations is to make it easier to build upwards by extending buildings towards the sky. The first regulations, permitted development and miscellaneous amendments, amend regulations introducing a new Class A into the GPDO, new dwelling houses on detached blocks of flats. This grants the right to extend purpose-built blocks of flats upwards by 2 additional stories. The blocks of flats must consist of 3 stories or more before the extension and can't have a total height of 30 metres or more with the additional 2 stories added. The regulations also require that anyone seeking to use permitted development rights to change the use of premises to residential will need to ensure that all habitable rooms have adequate natural light. The General Permitted Development England Amendment number 2 order came into force on the 31st of August 2020, creates a series of new Class AA enlargement of a dwelling house by the construction of additional stories, new dwelling houses on detached buildings in commercial or mixed use, Class AB, new dwelling houses on terrace buildings in commercial or mixed use, Class AC, new dwelling houses on terrace buildings in use as dwelling houses, and Class AD, new dwellings on detached buildings in use as dwelling houses. Each class allows for the construction of up to 2 additional stories of residential accommodation, or 1 story if the existing premises only has 1 story, subject to the prior approval of specified matters by the local planning authority and subject to other certain limitations, including restrictions on height and the requirement that the old buildings have to have been constructed between the 1st of July 1948 and the 28th of October 2018. Thirdly, the Town and Country Planning Amendment number 3 order introduced a new permitted development right for a Class ZA, which allows the demolition of a single detached building in existence on the 12th of March 2020 that was used for office, research and development or industrial processes, or a freestanding purpose-built block of flats and its replacement, subject again to certain limitations, an application for prior approval by an individual detached block of flats or a single detached dwelling house. The old building must have been built before 1990 and have been vacant for at least 6 months before the date of the application for prior approval. The ink on the statutory instruments, which I've just very briefly summarised, including the use classes order, was not yet dry when a challenge was issued to them by a community action group, Rights Community Action. The claim was brought on 3 grounds. First, the Secretary of State failed to carry out an SEA, that it breached the public sector equality duty and failed to take account of consultation responses and other material considerations, including to conscientiously consider consultee responses, to take into account expert reports that it commissioned on numerous related issues, and it was alleged to fail to turn his mind to the issues raised regarding the proposed reforms, and the Secretary of State adopted an approach which was unfair, inconsistent and or irrational in the context taken to similar other proposed reforms. The claim was heard by way of a rolled up hearing on 14th of October, so the Commission and the substantive claim will be determined in one go, and an outcome is expected relatively shortly, so this is one to watch this space. I've necessarily only given a very overview presentation of these very important changes at a relatively high level. Some colleagues from 39 Essex Chambers have recently presented a webinar which is available on 39 Essex's website, which goes into the change of uses in more detail as part of 39 Essex's 39 webinar series, which is available on our website. So turning to some Welsh planning law specific updates. Unfortunately, as Rich said, we can't be physically in Cardiff today for obvious reasons, but I'm going to speak on a couple of legal developments in Wales, one which relates to matters that occurred on Welsh soil that has wider implications, and the other, which is unique to Wales. I put in some pictures of some Welsh hotspots, including my hometown of Philly in the bottom left-hand corner. I can't offer a prize if you guess the others, but let us have your answers on a postcard. So the first development, which, as I say, happened in Wales, which has significant national implications, is the case of Hillside Parks Limited and Snowdonia National Park Authority. There's a picture there from the heart of Snowdonia National Park, but Hillside Parks concerned a development on the hillside of Balkan Hill in Abu Dhabi on the southern tip of the national park. The background facts were that planning permission had been granted by the then local planning authority, Merioneth County Council, in 1967 for the development of 401 dwellings across almost 30 acres of land. Building the first two houses commenced in 1967, but due to complications related to the site, development ceased. Planning permission was applied for. A series of planning permissions for departures from the master plan were applied for, granted between 1967 and 1974. And in January 1985, a dispute arose between the then developer and the then local authority concerning the validity of the 1967 permission. A claim was issued which sought declarations as to the status of the original 1967 permission. Pursuant to that dispute, judgment was given by Mr. Justice Drake in 1987, and an order was made granting 4 direct declarations to the effect described in the slide. But of particular importance to the Hillside Parks Court of Appeal case was the 3rd declaration, which stated that the development permitted by the January 1967 permission had begun, and that they may therefore be lawfully completed at any time in the future. And it was that declaration which was an issue in the Hillside Parks case. And as the Court of Appeal notes, at that time, the power to vary a planning permission didn't exist, and only exists in limited form even now, since amending legislation was enacted by Parliament in 1987 and subsequently. So between 1987 and 2020, Hillside Parks Limited acquired the site, which was the appellant before the Court of Appeal. Snowdonia Park Authority came into existence in the mid to late 90s. A series of further departures from the master plan were subsequently granted by the authority. And in May 2017, the authority contacted the appellant and stated that in its view, the 1967 permission could no longer be implemented because the developments which had been carried out with later planning permissions meant it was impossible to implement the original master plan. And the authority required all work should stop until that planning situation had been regularised. Hillside then sought a declaration from the High Court that the authority was bound by the ruling of Mr. Justice Drake in 1987, that the permission could still be relied upon, and that the planning permission may be carried on to completion, save insofar as development has been or is carried out pursuant to subsequent planning permissions granted for alternative residential development. The claim was rejected at first instance and upheld by the Court of Appeal. Mr. Lord Justice Singh held that he would accept the respondent's submission that there had been significant legal developments since the judgment of Mr. Justice Drake in 1987, and relied in particular on the House of Lords decision in Sage, which placed a great emphasis on the need for a planning permission to be construed as a whole. Lord Justice Singh said it now become clearer than it was before 2003 that a planning permission needs to be implemented in full and that a holistic approach is required. The Court of Appeal also endorsed High Court decision of Singh and Secretary of State for Communities and Local Government, in particular powers 19 to 20, where Sage was cited by the High Court, again emphasising and reflecting the holistic structure of the planning regime. For development to be lawful, it must be carried out fully in accordance with any final permission under which it is done, says the Court of Appeal. Hillside also relied upon a case called Lucas from the era of the 1967 planning permissions. In Lucas, plaintiffs sought a declaration that, again, an earlier permission was still effective and entitled them to carry out proposed development on the part of the site where it could still take place, even if it couldn't be fully implemented. And in Lucas, in 1967, Mr. Justice Wynne concluded that the earlier planning permission was not to be regarded in law as a permission to develop the plot as a whole, but as a permission for any of the development comprised within it, and accordingly it authorised the partial development proposed by the plaintiffs on particular facts. The Court of Appeal was certainly very keen to minimise the relevance of the Lucas case and said that it was a highly exceptional case that didn't apply to the facts before it. It said it was conceivable that a particular planning commission granted permission for the development to take place in a series of independent acts, each of which was separately permitted. However, said the Court of Appeal, that was unlikely to be the correct construction of a modern planning permission for the development of a large housing estate, where there would be court requirements concerning highways, landscaping, and so on, which are all part of the overall scheme. And it said that it's doubtful whether the developer can lawfully pick and choose different parts of the development to be implemented. And finally, earlier this year, the Welsh Government issued a pre-pandemic circular and direction for local planning authorities to refer certain planning applications to the Welsh ministers to enable them to decide whether they wish to forward in the application for their determination, which took effect from the 15th of January this year. In short, the 2020 direction requires local planning authorities, when dealing with applications for planning permission made on or after that date, to refer those applications to the Welsh ministers, whether they are minded to grant planning permission for residential development of 10 or more residential units, or on half a hectare or more of land, which is not in accordance with one or more provisions of the development plan in force. Further says that where a local planning authority is required to give such notification to the Welsh ministers, it must not grant planning permission on that application until the expiry of the period of 21 days, beginning with the date which the Welsh ministers tell the authority in writing is the date upon which they received information specified in the direction. The context for this change is set out in para 9 of the guidance that the Welsh Government published alongside the direction, which states that Planning Policy Wales requires development plans to be effective, focused and deliverable, and it says that it's essential that development plans are produced and reviewed and that allocations made in them are delivered in line with community expectations. The Welsh Government is concerned that speculative, unsustainable residential developments have been proposed outside of adopted development plans, and the purpose of the direction is to allow the Welsh ministers an opportunity to consider whether appropriate scrutiny has been given to such applications. And I'll now hand over to David Sawtell.
Thank you very much, Gethin, for that really informative discussion of some incredibly important changes to planning law. Can I echo what Gethin and Richard have said before me? I would have loved to have come to Cardiff and Bristol, and I've had many happy moments there, and I can only look at these two photographs to remind myself what these beautiful cities would look like on a crisp November morning. But alas, all I can share with you instead is some hot takes on property law, particularly in respect of restrictive covenants and proprietary estoppel. And these I've picked because they have a significant impact on how we develop projects, how we get them off ground, and how we ensure we don't run into any turbulence when it comes to private law challenges to developments. The first case came out of the Supreme Court last Friday, Alexander Devine Children's Cancer Trust against Housing Solutions Ltd. And it is all about a land use conflict, to use Lord Burroughs' term. Essentially, what the case is about is two properties, one owned by the Cancer Hospice Trust, the other one by a developer for affordable housing, and they both want to develop. One has restrictive covenant over the other, and that is likely to prevent these affordable housing units from being used. And both the Upper Tribunal and the Court of Appeal and the Supreme Court accepted that this would be a waste, and that would engage parts of Law Property Act Section 84, which allows for modification or discharge of restrictive covenants. Restrictive covenants are important because they are private law property rights. They sit independently of the public law regime, and I'll come on to look at the effect of that. They can also be used as well to protect positive obligations. So overage agreements where you agree to pay a sum of money in the future if, for example, a property is developed, and can be protected by using a restrictive covenant, such as we see in this case. Section 84 provides for a regime to discharge or modify restrictive covenants. They can become obsolete, or the character of the surrounding area can change, or there can be reasons why the continuing existence of restrictive covenants can be contrary to the public interest. And that's set out in section 84(1)(a), which itself was a 1967 amendment to regime of restrictive covenants. That's where continued existence would impede some reasonable use of land for public or private purposes, and would, unless modified, so impede the user. You then need to go on to satisfy that the impediment is contrary to the public interest. Section 84(1)(b) also modifies this, and this makes it clear you need to take into account the development plan and any declared or ascertainable pattern for grant or refusal of planning permissions in the relevant areas. So the regime of Section 84 appears to suggest there is a role for the upper tribunal to take into account planning and planning regimes in the area. As we'll go on to see, that role is really quite limited. So the facts of the case itself, this is being built on greenbelt land, and it arises out of a conveyance from 1972. And that restrictive covenant was put in place in order to protect an overage obligation. By the time we get to the relevant parts, that obligation expired in 1984, it's long expired, but originally it wasn't there to protect a hospice, it was put in there to secure the grant of a sum of money if the land was itself going to be developed. So the restrictive covenant itself prevents anything being built on this land other than a car park. You're only allowed to use it as a car park. And that is fair, it's registered, it's going to be obvious to all future owners of this land. So Mr. Barty Smith inherits the land from his father. His father originally sold it. He has the benefit of the covenant. And he makes a gift of the land next to relevant land, so a hospice can be built. Now, a property developer, Millgate Developments, acquires the encumbered land and is absolutely clear, is fully aware of this restrictive covenant, and also is held, it could have identified those who had the benefit of the covenant. In July 2013, the Millgate applies for planning permission to build affordable housing units on the land. But why is it done so? It's because it's linked to a separate application to build housing units for commercial sale. And in March 2014, planning permission is made for those more readily sellable units as conditional on provision of affordable housing, and in the end that's encapsulated into a Section 106 agreement. It has to transfer the units to an affordable housing provider. And in terms of planning, even though it wasn't appropriate to greenbelt and contrary to development plan, there were special circumstances that justified the grant of permission. So at first blush, it might be thought that Section 84(1)(b) might be engaged, but no, it will not be. Very important point is that Millgate could have chosen to lay out the development of affordable housing unit so that it did not breach the restrictive covenant. It could have used the land for car parking for the entire development and put all of the housing units onto unencumbered land, and it would have obtained planning permission, but it chose not to do so, and that was a very important point when it came to the Supreme Court. So before it's made any application to the upper tribunal to discharge the restrictive covenant, it begins clearing the site. And Barty Smith, who, as we remember, made the original gift of the land, he becomes aware of development when he flies a light aeroplane overhead. So this really is something that's been built without notice and without telling those who have the benefit of the restrictive covenant. And he writes to object to the development, but Millgate continued to build. And in July 2015, they finished the development. 13 affordable housing units are built on the encumbered land. They agree to sell the development to an affordable housing supplier, and then they apply to the upper tribunal to modify the restrictive covenant. And one Lord Burrows of the Supreme Court presented them with a fait accompli. September 2015, the construction of the hospice begins. And subsequently, the housing units are occupied. So you can see by the time it gets to the upper tribunal, we have a land use conflict. We have built up units, affordable housing units in demand, and we also have a hospice that's going to be built, and these housing units are going to affect the privacy and outlook of the grounds of the hospice. So the upper tribunal holds it does have an interference, and it also holds restrictive covenants should be modified under section 84 under the public interest exception. It orders Millgate to pay £150,000 as compensation to the trust as condition of that modification. And the trust appeals to the Court of Appeal. And the Court of Appeal allows the appeal. And Lord Justice Sales, who's now Lord Sales in the Supreme Court, gives the only substantive judgment, and he gives a very robust judgment indeed, lamenting the conduct of Millgate in pursuing its development, and says this in itself is contrary to the public interest. Now it goes to the Supreme Court, and it's interesting because it's Lord Burrows who gives the only judgment of the Supreme Court. And I note, as a matter for trivial pursuit, he's the first Supreme Court judge to be appointed directly from academia. Of course, Lady Hill joined the House of Lords in 2004. So it's also an interesting case to see an early decision of Lord Burrows in the Supreme Court. First of all, the public interest test. Lord Burrows made it clear we have to focus narrowly on the impediments to a reasonable user of the land and ask whether that impediment, the impediment itself by continuation of the restrictive covenant, is contrary to the public interest. So at this stage, the jurisdictional stage, the conduct of the applicant is irrelevant. Instead, conduct becomes relevant when we get to the stage of the discretion of the upper tribunal. Once the upper tribunal has jurisdiction to modify or discharge the covenant, should it in fact exercise its discretion to do so? And there's a point which emerges, which I think has a wider application when it comes to private law rights, and that's the fact that this was a cynical breach. And Lord Burrows quotes an article from Peterborough about restitutionary damages and notes that this was a deliberate breach of a restrictive covenant with a view to making profit. But does that mean the upper tribunal made an error of law? And Lord Burrows made the point that it is in fact a specialist tribunal. It isn't simply enough when considering the decision of a specialist tribunal on a point of discretion to simply say you disagree, that you have to say that they made an error of law. And one gets the impression one has to look quite hard to find that error of law, but there are two, and they are omissions to deal with two relevant points. First of all, as we noted, they could have submitted an alternative plan. They could have developed the site so as to ensure the restrictive covenant was not breached, but they chose not to. And secondly, which to my mind, even though it comes second, might be a very important matter, particularly when we come on to consider in another case the question of remedies. It is Millgate, or it was Millgate, who had created this state of affairs. They had created the waste housing units in the first place by way of this deliberate breach. They probably could not have made out the public interest test at all if they hadn't built the houses. So building the houses and the bungalows came first and actually opened the door to get the jurisdiction under Section 84. So I think that creating the grounds upon which you rely in deliberate breach is probably going to be a very powerful factor moving forward, looking at future cases. Now, when the decision got to the Court of Appeal, Martin Dixon, in an editorial in the Conveyancer, didn't really mince his words, and he said, this sounds a warning to those who think that covenants and those that enjoy their benefit are just interfering busybodies or standing in the way of progress. Also makes it clear that proprietary obligations are exactly that, and not to be disregarded when they are inconvenient. So I mentioned the question of planning. And this is what Lord Justice Sales said in the Court of Appeal. And Lord Burrows didn't really say anything to go against this paragraph of Lord Justice Sales's judgment. He said that grant of planning permission does not generally have any impact upon private property rights. It is a decision taken regarding what development of a particular site can be regarded as acceptable in planning terms, with reference to the public interest. And then went on to note, and in fact, that's unlike a planning authority would have viewed as his role to use planning powers. And this, I think, is orthodoxy. And I've put up there Shepherd and Turner, where Lord Justice Carmore, who is of course now in the Supreme Court, said the general purpose is to facilitate development and use of land in the public interest, having regard to development plan, pattern permission in the area. Section 84 seeks to provide a fair balance between the needs of development in the area, public and private, and the protection of private contractual rights. Also in the case, there's a decision that came out in September, which I represented the objectors for in the upper tribunal. In that case, the applicants relied quite heavily on the fact that planning permission had been granted and referred to different factors which affected the grant of planning permission, noting and correlating those with the test to be applied under Section 84. But ultimately, the upper tribunal didn't really place much weight at all on the grant of planning, and instead chose to go down the statutory test of impediment of a reasonable user. So I think that this collection of decisions means that the public interest test and planning is going to be kept quite narrowly confined when considering discharge of restrictive covenants. And Lord Burrows cited, but did not do anything at all to disturb the analysis given in A. Ray Collins's application, that if you're going to succeed on the ground of public interest, you must show the interest is so important and immediate as to justify the serious interference with private rights and the sanctity of contract. Now, of course, this is simply going to be phase one of any conflict between the parties. Restrictive covenant is up and running. These buildings are sitting there in breach of covenant. The next stage, of course, would and has been taken, is to apply for an injunction seeking the demolition of these buildings. And that's going to be quite interesting, because that engages the kind of decision-making that we saw referred to in Coventry and Lawrence, Fendel and Tiger's case. Got 13 perfectly good affordable housing units, is, albeit built in a deliberate cynical breach of restrictive covenant, is the court now going to ask for them to be demolished? We'll have to wait and see. Now, I've written a slightly longer piece on the decision, which on the 13 Essex Chambers website, which goes into a little bit more detail about some of these very important and powerful issues. So let's move on. Let's go on to something quite different, proprietary estoppel in 2020. And why have I got a picture of Bristol in the snow? It's because this quote of Lord Justice Lewison in Haberfield and Haberfield, Robert Frost's poem, stopping by woods on a snowy evening. The woods are lovely, dark and deep, but I have promises to keep. And this was a case about a family farm which is close to Yeovil in Somerset. And here the judge, on the issue of remedies, made an immediate award of cash to the claimant. The idea was the claimant wasn't going to be interested in having her interest postponed, expected to receive some benefit of this, and the judge concluded that after the sale of the farm, the claimant would have received a sum of money. And that was entirely within the discretion of the judge. And Lord Justice Lewison said, and the reason why he quoted the poem, notwithstanding the fact it's a lovely piece of writing, that underpinning the whole doctrine of proprietary estoppel is the idea that promises should be kept. We were not shown any case in which a rejection of an offer, because here an offer had been made to claim for a lesser interest, who had kept her side of the bargain should receive nothing. Now, 2020 has been all about, in the Court of Appeal, the development of what the approach of the court should be when it comes to the question of remedies. Because cases such as Davis and Davis in 2016 really laid out proprietary estoppel on the slab and established what it means when it comes to liability. But 2020 was all about the idea that we're trying to give the court a broad brush approach to granting the appropriate remedy in the circumstances of the case. But why is proprietary estoppel significant in a development landscape? It isn't simply about promises being made about family farms, which is a comment that was made also in the conveyance, I think in a series of articles now. So it isn't simply about family businesses. There's also about, for example, easements being argued against a local authority. And there are two cases now, including a very important case of Crabb and Allen District Council. Also about development agreements for payment. And in that case, in Yeoman's Row Management Limited against Cobb, the House of Lords held that wasn't appropriate to make an immediate order. And also note, this can also rise in disputes arising out of invalid option to renew a lease. So you might very well think that an argument as to proprietary estoppel can be raised to try to establish a number of property rights and or to seek to claim some payment of immediate sum of money. So given that, it's important to see how we advise our clients. If promise has been established, if liability in respect of proprietary estoppel has been made out, what should the claimant expect to receive? And starting with a Privy Council case from last year, it's all got a little bit more vague, I have to say. At one stage, looking at the Yob and Coleman Road, the Cobb case, it seems to be suggested you needed quite a certain assertion. But of course, proprietary estoppel isn't simply a promise-based cause of action, it's also about acquiescence. And the Privy Council there made it clear you don't necessarily need to be looking at a very clear assertion being made at all. In this case, it could just be by standing by. That could be the representation that the claimant relies upon. And the uncertainty of any assurances that will be given may not necessarily be fatal to the claim. So that's quite important, and it's something which is picked up on in a number of cases in the Court of Appeal this year. So first of all, Guest and Guest. This was a farm in Sedbury near Chepstow in Monmouthshire. And the case is very useful because it is probably the latest leading distillation of the test for proprietary estoppel, so picking up on what Lord Justice Lewison said in Davies and Davies. And it has the classic kind of forma major style representation. So to quote paragraph 18, in the course of 15 years during which Andrew worked on the farm up to 1997, David would shut down disagreements of Andrew over farming decisions by saying, "It's my farm, but when you take over, you can do what you want," or words to that effect. And over the years, as the judge accepted, there are a number of these occasions when David said things which implied that Andrew's time would come. And in the end, the judge allowed the claimant a life interest in the farm, together with a lump sum payment for the value of the sum after tax. So here we can see that we have a rather uncertain representation being made to the claimant, and then the judge giving a not very uncertain at all remedy, namely a life interest and a lump sum payment. So what we're looking for here is, well, how do we get from one to the other? And the appellants relied on this dicta from Lord Justice Carman and Cravenel and District Council. Is it a two-stage or three-stage process? What was suggested there was, first you see if the equity is established. Can you even bring a claim of proprietary estoppel? Secondly, if you can, what's the extent of the equity if it is established? And then thirdly, what's the relief? This seems to suggest that the discretion given by the judge should go through 3 stages. And it was suggested the judge had got it wrong by not asking himself what the extent of the equity actually was. No clear promise or commitment to pass on a particular interest. Therefore, it was submitted. The court fell into error by having regards to the extent of the equity. And that was held to not be the correct approach. That was held it should really have a 2-stage approach. 1, is there an equity? 2, how do you satisfy it in order to do justice? There's no intermediate stage. Instead, possibly with a single test. What's necessary to avoid an unconscionable result? Now, this is quite important because there's quite a serious academic argument about the nature of proprietary estoppel, the role of unconscionability, and what effect a finding of an establishment of an equity means in terms of remedies. The idea you could have a sliding scale between what should be awarded and the quality of the promise and the detriment, and it being quite a fine calculus. But the idea that this can all be collapsed into a single question will make it quite difficult potentially to advise clients in the future. The test of what's necessary to avoid an unconscionable result. Are we going back to something akin to the test of how long is the Chancellor's foot, which is not, one might say, appropriate when we're advising something such as an option on a lease or development agreement or an easement. Another interesting case, which is fairly hot off the press, a farm in Dorset, Drake and Swift, brings out a very interesting point of insolvency law and proprietary estoppel, and for whether or not finding or potential as an equity giving rise to a proprietary estoppel can survive an insolvency event. Is it property within the meaning of the Insolvency Act of 1986? Well, there's a picture of a farm. What we're dealing with is number 2. We're dealing with a cottage there, which is on part of the farm site. And there was a dispute about the ownership of the property. And that never really got resolved before the claimants, or the applicants in this case, became bankrupt. And what the bankrupts were seeking to say is that they could have this equity arising by way of proprietary estoppel revested in them under section 283A2 of the Insolvency Act. And so it's also a really important decision in terms of a thorough analysis of section 283A by His Honour Judge Matthews, sitting as a judge of the High Court. What section 283A2 says is that discharged bankrupts can bring a claim or can have a claim for an interest in land to be revested in them. And it arises where property comprised in the bankrupt estate consists of an interest in a dwelling house, which for date of bankruptcy was the sole principal residence of bankrupt or their spouse or former spouse. And it should automatically revest in the bankrupt, subject to a number of exceptions, such as realisation or sale by the trustee. So in terms of the facts of the case, in 2012, Brakes claimed an interest by way of an equity rise by proprietary estoppel in the cottage. That claim was stayed, unvindicated, never adjudicated upon. However, they were found bankrupt in 2015. In 2019, they commenced proceedings against the trustee in bankruptcy for declaration of the interest in the cottage, of course, if they had any, had revested in them. So was the dispute partnership property? Was it beneficial property of Brakes? And there was a question about that as well. Because what had happened was that the trustee in bankruptcy, Mr. Swift, had entered into a transaction with the liquidators of a separate partnership in relation to the cottage to get the liquidators' rights, and then entered into a back-to-back transaction to pass it on to another company, Cheddington Court Estate Limited. So the overall facts of the case were quite complicated. But the key issue was, for our purposes, does this equity arising by way of proprietary estoppel, is it capable of being property within the meaning of the Insolvency Act? And the finding by the Deputy High Court Judge was, yes, it was. It is proprietary and it can bind third parties, even though the court has not adjudicated upon it. So for the purpose of general law property, that's right. But also it's property for the purpose of falling into bankrupt estate for the purpose of section 283. Where the claim failed was it wasn't their principal residence. Instead, it was the main house on the site. And so the claim for declaration, in fact, failed. But it's a really important decision, I think, when considering insolvency and proprietary estoppel. If you're advising an insolvency practitioner and someone emerges and has a claim with respect to proprietary estoppel, it's important to pay close attention to such a claim. The next slide illustrates the potential way in which proprietary estoppel could be used outside, as I say, the scheme of family businesses. Here it's about a community centre in Brent, and first defendant, in the claim for possession, had identified a site for this community centre a long time ago. The local council supported the project, purchased the site, and the purchase price was paid for by a number of grants and the local council. But time moves on and the local authority decided to sell part of the site to facilitate the redevelopment of a new community facility. So a claim applied for restriction against a title, brought proceedings for a declaration. So we've got cross claims moving backwards and forwards between the parties, but ultimately one person, Johnson, sought a claim saying, actually, I have beneficial interest in the land. It doesn't legal. Right, the London Borough of Brent might have a legal interest, but they can't simply go and sell it. Well, first of all, it was held he had no locus to bring the applications. He didn't have a sufficient interest. But the case does go on to consider a number of different claims. It discusses, for example, the equity in Paddington Morgan, which is subject, I would suggest, of a different webinar altogether. But it also considers, amongst a number of other heads of claim, proprietary estoppel. And it was held it could potentially have arisen if they had made representations that would enjoy some right or benefit over the property, which they have subsequently denied to Johnson. But here, the representations were said to be simply too vague, had no credibility, and not being supported. Now, I have to stand back and look at that line of cases and say the idea of an assertion can be too vague makes it quite difficult to advise clients in the future, because you have some very unclear assertions being made. You also have some which for one side allow a claim, and other ones which are apparently too vague. I think it's more of a point is what was said to be represented, and here the property was being held for the benefit of the community. So it's not a representation, it's going to be a property being held on trust for Johnson and the other defendants. So I think that's going to be a very important point to bear in mind going into the future. Now, I have earlier this year written a short article about some of the interesting developments of proprietary estoppel in the first part of this year. Also note, in summer, second edition, Law Proprietary Estoppel came out by Ben McFarlane of the University of Oxford. A really interesting book, and tries to bring some order into this mass of cases, and certainly well worth looking into, and very highly regarded. First edition very highly regarded. I'm sure the second edition will be as well. So certainly I suggest always play for when it comes to private law rights in terms of development in Bristol and Cardiff. And again, as Richard noted at the outset, any question and answers, we're leaving time for them at the end, so please do pop them into the Q&A box and we'd be more than happy to deal with them. And now I hand over back to Richard.
David, thank you. That was a run through some pretty important issues when it comes to carrying out development. I'm going to talk about two topics. First of all, a decision of the Court of Appeal from just under 4 weeks ago, Swindon and Symmetry, and then I'll come on to the question of statutes. The Symmetry case is one which considers the scope of planning conditions, in particular what they're capable of doing. David, you want to move onto the next slide? This particular issue is whether a planning condition can require land within the application site to be dedicated as a highway. The context in the Swindon situation is that there is a huge new settlement proposal underway called New Eastern Villages, and a whole variety of interconnected areas of district centre, lots of residential and employment. It's generated a number of cases in different forms already. There's quite a high profile planning appeal from 2 years ago called Lockmead, even more high profile costs award against the developer in that particular case. They've now subsequently got consent. There's been a CPO inspected part of the site. But this concerned an employment area, which is known now as Symmetry Park. And we look at the map of the scheme. You see there a variety of large areas which is intended for very major employment uses. Going down the west side of the site is a north-south road, and halfway along that is a roundabout, and there's an east-west road. Those are shown connecting at the top to the existing A420, at the bottom, so the south side and the east side, feeding into the remainder of the NEV scheme, which is currently still greenfield. When we come to the planning permission and the application, the developers in the design access statement addendum said that these would be highways and were there to connect with the rest of the NEV. The local authority, when it granted planning permission, said that proposed access roads and all of roads that serve a necessary highway purpose shall be constructed in such a manner to ensure that each unit is served by fully functional highway. So is served by fully functional highway is the sort of the key to that. That had sort of proceeded, including at reserved matters stage, on the basis that these would be highways, but then the subsequent developer, involved in reserved matters, but subsequently a little bit of a view as to how they wanted to proceed, said, well, actually, there's no obligation to dedicate the access roads as highways. We are entitled not only to stop anybody else using these access roads, but actually to charge a license to allow somebody to connect to it, particularly with an eye on the future development to the east and to the south. They applied for a certificate of lawfulness of proposed use of development to certify that these roads could be used only as private roads, so they didn't have to be used by the public. The inspector agreed with them, and the High Court, the Mrs. Justice Andrews, as she then was, she's simply been promoted, agreed with the local authority's challenge to the decision a case where I'm acting for the local authority, Swindon Council, and she considered that the planning condition required the highways to be dedicated on those roads. Important point to have in mind is that it's not at all suggested that the condition would require either the highways to be adopted by the local authority, so become a local authority highway land in that sense, attainable at public expense, nor to require any transfer of land to the local authority, simply that they be highways. Secretary of State did not appeal, but the developer Symmetry did. That appeal has just been allowed by the Court of Appeal. Application for permission to appeal to the Supreme Court has gone in, I think, within the last couple of minutes. So what have the Court of Appeal said? First of all, the Court of Appeal accepted that highway means public right of way. So there's an ordinary and sort of legal meaning of that, and certainly don't make clear that there's any difference in interpretation here. So they said, well, the most natural meaning of the condition is that it requires that the highway is dedicated. However, they said that if that condition was what the condition meant, then that would be unlawful. Because going to a 1964 case, Hall and Shoreham on Sea, they said there was a principle that a planning condition cannot require a highway to be dedicated. And what had happened in the Hall and Shoreham on Sea case was that a minerals operator had sought planning permission for some aggregate handling facilities for seaborne minerals. That was adjacent to a quite busy road. Local authority, not terribly happy about more connections to the road, so imposed a condition saying that if they called on it, it's only if they called on it, Hall would have to build an ancillary road, a secondary road alongside the main road, and connect that up to any other ancillary roads built along that frontage and allow passage along that. So you'd have simply sort of two connections to the highway, close up their existing highway connection if they do it, two connections, one at each end of the road. Hall had challenged that. Now, there's some very good reasons for saying that that was a condition which, in the circumstances, was a fundamental alteration to the application and was unreasonable on normal fact-sensitive grounds. But the Court of Appeal also declared that whilst you could have a condition which allows access to other people over land, requires that to be given, a condition which required dedication of a highway would be unlawful because that sidestepped the statutory right to compensation which would arise on a compulsory purchase order. The Court of Appeal in the present case, Swindon, considered that they were bound, as I say, it was binding at this judicial level. Now, this is a situation where it was accepted that the planning obligation could require dedication of a highway. How did the court then resolve that? They applied interpretation, what's called the validation principle, which is that if you have two potential interpretations of a document and one of those interpretations would lead to an unlawful outcome, then you'd adopt the other interpretation, which is a lawful outcome, provided it's a realistic interpretation. So while Swindon's interpretation was, they said, the most natural one, it would be unlawful, and Symmetry's interpretation, while it's not the most natural interpretation, would be a lawful outcome, and so ought to be pursued. We'll see, of course, whether the Supreme Court decide to take that on and what comes to it. Second topic I'm going to talk about are public statutes, and this is an issue which got particular attention over the last couple of months, and particular attention in Bristol as a question as to whether and how and why particular public statutes of historic figures, some of whom had distinctly more dubious backgrounds than others, ought to be removed and how that should be done. We see an example of the most notorious removal, which is a statue in Bristol of Edward Colston, who was very heavily involved in the slave trade. That statue was removed by a crowd, dragged off its plinth and thrown into the harbour. Now, it's a Grade 2 listed building. Yes, we can talk if we wanted to about offences to listed buildings, but actually in pure criminal law terms, the key element of that wasn't the listed building offence, but it was criminal damage. There's no consent from the owner to do that. Under the sentencing guidelines, the heritage impact would be an aggravating factor in terms of sentencing, of dealing with that. But let's assume that we're looking at a far more orderly process for considering whether or not a particular statute should remain. What are the legal constraints and the legal issues which are involved in doing that? And frankly, it's a little bit complicated, but apologies for that. So is it a building? Is it a fixture? Is it a skeleton of a horse with a bow on it, one of its front legs? Here with the 2015 temporary exhibition on the fourth plinth on Trafalgar Square by Hans Hack. Lots of different questions arise. Is something, a building is going to have an effect on both questions of planning control and questions of listed building consent? Is it a fixture? And you've got some things which are going to fall outside that entirely. So what's a building? And we now have a unified approach endorsed by the Supreme Court in decision early this year in Dill. Say a little bit more about the facts of Dill in a moment. As case acted for the successful appellant, and that dealt with what we see on the right-hand side, which were lead urns mounted on limestone plinths. They were listed buildings in their own right, according to the Secretary of State. Quite tall, about 2.7 metres, although that didn't stop Lord Carnwell from constantly referring to them as vases. That gives a hint as to where that subsequently goes. But what the Supreme Court did was to look at the question, what's a building in listed building terms? I say, well, that's the same as the approach you take in planning permission terms. And there are three facts identified in a case called Skerritt, which concerned a marquee: size, permanence, and degree of annexation. Now, that affects whether in planning terms, what you do to create that object amounts to a building operation. Because if the end result is a building, there's a fair chance that you do a building operation to get to it. And also, to be listed, something to be listed in its own right, it has to be a building. So those are the three factors to be looking at. Another issue is the question of fixtures. Whether something is attached to a building or attached to the land. And that comes in on two particular contexts. First of all, in terms of listed building control, in addition to a building as a building on the list, there's an extended definition, which it also includes any object or structure which is fixed to the building and any object or structure within the curtilage of the building which forms part of the land and has done so since before 1st of July 1948. So whether something is within that extended definition depends on whether it's fixed or whether it's part of the land. Also relevant where we're looking at whether something is part of a building which is then subject to planning control, and that bears us whether or not removing it constitutes an alteration to the building. So what is a fixture in this particular context? There are two tests which are looked at, and they derive from property law. One is to look at the degree of annexation, and the second is to look at the purpose of annexation. Degree of annexation, broadly speaking, means that something which is not attached, resting on its own weight, prima facie, is not going to be part of the land or fixed, unless perhaps you have to dismantle it to remove it. Purpose of annexation tends to be more important. It's particularly in terms of works of art, you're looking at, is it there sort of fixed in some form as a way of appreciating the work itself, in which case it is likely not to be part of the building or the land, or is it there as part of the design of the building or part of the design of the garden, whatever it is. If it falls outside those, it will be a chattel and will not be capable of subject to listed building control within the extended definition. Now, if we look at the question of listed buildings in this context, we've got those questions: is the building its own right? Is it fixed or within its curtilage? And an aspect of that question, is it a building, is whether there will be works of demolition or alteration in terms of its removal. And Lord Carmouth talked about demolition as meaning dismantling. So if you can remove something easily in one piece without causing any damage to anything, then that's perhaps a pointer that it's not a building or it's not fixed. In the Dill case, the Supreme Court said that the urns would not, if you were looking at the property law tests, so if they looked at whether they were part of lands being within curtilage, the property law tests would not be met in the context of the urns. They had been moving around from various properties and had only arrived in the particular site, Idlicott House, in the 1973, being listed then in 1986. So they wouldn't be part of the land in that sense. The Supreme Court left open the question whether they would be buildings, but gave a very strong steer that the listed building enforcement notice in concern should be withdrawn, which is what has subsequently happened. So listed buildings, those are the steps to go through. But how do you deal with buildings which are not of listable quality? And we see a few things which aren't of listable quality, like this bust, which was outside Madeira Airport. It's subsequently been replaced by a rather better representation of Cristiano Ronaldo, but it's a photo that raises an awful lot of questions about what is art, and also the question as to why my daughter, who plays for Southampton FC and supports Chelsea women, is wearing a West Ham shirt. But you have a lot of statues which are not listed, and if they're going to be subject to any control, it's going to be subject to planning control. That raises a number of issues to try and deal with. Firstly, is what's being done an alteration or is it demolition? If it's attached to a building, it's more likely to be an alteration. If it is part of a building or within a building, is it simply not subject to control by provision on internal works or on non-material changes to the exterior? There are some PD rights which apply to alterations that may assist. For example, railway stations, although in practice they're probably only going to protect statues of Isambard, Kingdom, Brunel. The demolition direction excludes from the concept of demolition, so from the need for any planning permission, buildings which are smaller than 50 cubic meters. So most statues on plinths would not be demolition in planning terms. If they are demolition in planning terms, then there are permitted development rights which have a limited degree of prior approval. Conservation areas, where very many statues are in, will be subject to a slightly different regime. The demolition direction will still apply, but there's the question of relevant demolition, which also requires planning permission. Now that applies to buildings over 115 cubic meters, so those will be needing planning permission in any event, and the prior approval provision on the permitted development regime will not apply in those circumstances. You'd have to apply for planning permission. That's probably not going to apply to very many statutes. Something which may kick in slightly more are what are referred to as pre-1925 tombstones. But tombstones is defined as monuments or memorials to a deceased person which were in place prior to 1925. They need to have been deceased prior to 1925 as well. So long-standing statues in conservation areas may well be subject to that requirement for planning permission, where they are, even if they're not actually listed buildings. Another aspect to watch out for on control are planning conditions. And it's not unusual on more recent consents for conditions to be imposed on the planning permission, which would require public art to be in place and maintained. And quite a high profile example of that is what we see here, which is we see one of the heads of the Desert Quartet. And those are sculptures which were put up in Worthing. If you go to Worthing, this is probably one of the things to really look out for in Worthing, but the put up in Worthing at the back of a shopping centre. Back of the shopping centre, not looking terribly attractive. And so there's a condition saying there have to be sculptures erected on a loggia at the back, and the condition said sculptures be kept there unless otherwise agreed with the local planning authority. When the owner who'd sold off the shopping centre many years ago but kept control over this part of it decided he wanted to replace the sculptures with something a lot less valuable. Sculptures by Dame Elizabeth Frink. The Secretary of State listed them, and they are one of the most modern of listed buildings. So do watch out for conditions which keep some sculpture and statues in place, particularly where they're connected with relatively recent developments. Now, who makes the decisions on this? There was a press report a couple of weeks ago that given the controversies and the wide variety of interests about whether or not certain historic statues should be removed, that the Secretary of State should take a rather stronger role in that decision-making process to enable a wider range of views to be filtered through that. Now, as you will have seen from the analysis we've just gone through, the level of control in the non-listed building context is presently rather limited at all by any authority. And so there need to be a degree of looking at that if there's going to be a major change in those. Also, the notification provisions, even on listed building control, are relatively limited for alterations, rather more so on demolition, and very much reliant on historic England becoming involved. So we'll have to see how this all works through in terms of changes to the regime. But looking at the back of this is, if you do have control, what do you do with it? How do you exercise that? And this is where some of the issues about the desirability of keeping up monuments to perhaps some distinctly unsavoury characters do bump up against other considerations. Where something is listed, or for that matter, it's a conservation area, then special regard has to be given to the preservation of historic or architectural interest. And to look at some of these issues, the Historic England Commemorative Structures Guide on selection of listed buildings is a particularly good place to start. The one on gardens is also quite useful in terms of things which are in a private location. There's a question to what extent things have artistic interest. The significance of the person who is included may well add to historic interest and actually be a reason for listing. Now, maybe a question as to how far the significance of that person is affected by their character and what is now considered their behaviour as opposed to what may have been the view taken of them a long time ago as a local benefactor. The degree to which there is a public or private location is certainly going to be important in terms of looking at particularly historic significance. But we're looking at the special interest of the statue if it's listed, but countervailing that is also public benefit. And if there is seen to be a good reason to remove an unsavoury statue of an unsavoury character, then public benefit may well be what you choose to hang John Betterman's hat on. So those are some thoughts on sculptures and listed buildings. What we'll do now is turn to a couple of more general questions which have come in to us, and I think it probably brings Gethin and David back into discussion, and probably I think first a question for you, Gethin. How should you interpret and apply local plan policies which refer to the old use classes that no longer exist?
So, yeah, well, I think the status of those local plans, the parts of those local plans that refer to the old use classes, is now something of a vexed issue and a matter, I think, some scope for debate. But essentially, there's some real force in the view that those passages now essentially rendered irrelevant. They may assist in justifying prospective conditions, which I'll come on to in a moment. But I think it's also important to bear in mind that local plans themselves will look very different and may well have a different role come next summer. The white paper proposes, among other things, that local plans will become visual and map-based, based on digital technology supported by a new template, and that they will set parameters for development rather than making policies to guide discretionary decisions. So they may well be a focal point for this shift that the planning reform paper highlights from this rules-based, from this discretionary-based to a rules-based process.
Okay, so related to that, I have a question that's is a situation, no doubt entirely hypothetical, of course, where planning permission is granted for 2 flats and retention of part of a B1 use on an existing B1 building, could a council impose a condition or post the changes to Class E, restricting the use of the remaining non-residential part, restricting that use to a B1 use? What's the thought on that?
I think the first point to bear in mind is that the MPF specifies that conditions should be kept to a minimum and only imposed where they're necessary, relevant to planning, and those tests are set out at para 55. And the planning practice guidance also emphasises that planning conditions must be justified. So before we even get to the question about using descriptions of the previous use classes as a condition, you have to satisfy that quite stringent hurdle of making sure that the condition is justified. But whether or not then a condition could be used to restrict a use within, say, Class E, subject to meeting those thresholds, will turn on the particular circumstance of the individual development. I can see it may well be possible to use description of previous use classes to restrict prospectively the use of a class within E for a condition, as I say, if it meets those strict tests for imposing a condition. I think what would be much more difficult, if not perhaps possible, but would certainly be very difficult for the LPA to do, would be to take a blanket approach to attempt to impose restrictions as a matter of course by way of conditions, simply to uniformly sort of avoid the effects of the amendments made by the 2020 regulations. I think that kind of approach is certainly unlikely to meet the test. Would be pretty risk laden.
And it's always been possible to have a restriction within a use class. So, for example, a condition which restricts retailing to non-food retailing. But of course, you need to have that justification. And one quite important difference with the fact it's in the use classes rather than these being broadened by permitted development rights is it's not possible to use an Article 4 direction to restrict within the use class. You can only restrict within the use class by imposing a condition in a situation where somebody has had to get planning permission, and something that undoubtedly is going to crop up, is the effect of existing conditions on planning permissions for things which fall within Class E use classes and the restrictions that will have. Well, that's, I think, the questions we've got. Thank you, everyone, please, for listening and joining us. On our website, we have both details of the webinars coming up and recordings and the slides from previous webinars. These from today will be going up over the next day or so. We also have a series of podcasts covering a whole range of topics. David has a number of other colleagues in Chambers discussing adjudications called EWCA. We have a planning, environment and property podcast series. Most recent installment of that is John P. Smith talking about Greenbelt cases, but you can also catch me discussing planning debate over a relic of the Cold War, how planning permission was extended to the demolition of buildings, and a series of short videos by Stephen Tromans discussing various environmental topics as he takes walks around East Anglia. So a lot of material to look at and enjoy. Our podcasts are also available on the Apple Podcast series and Spotify. So lots of ways to catch up with us. And I hope in the not too distant future, we will, as the Queen said back in April, we will meet again and look forward to seeing everyone in person at some point in 2021. But that's all from me and all from 39 for this afternoon. And thank you very much for joining us. Thank you.
Thank you very much.